It is inhuman. I know that you can get into an interesting argument, which is that it's the very fact that so many of them remain on death row for so long that has actually saved the lives of some of them because of, for example, the discovery of scientific advances such as DNA, which is actually now not irregularly leading to somebody being exonerated, because if they were convicted 25 years ago, before anyone had really certainly developed DNA technology, if they were convicted on the basis of a blood stain, and it was nobody knew about DNA, and now when it's DNA'd, it turns out it wasn't the victim's blood on their clothing or their blood on the victim's clothing or whatever it was. People are being exonerated. Now, if you had a system whereby they only spent 5 years on death row and they were then executed, they would have been dead. So it's a bit of an irony, because some years ago the Privy Council in the United Kingdom held in relation to a Caribbean death row case that it was cruel and unusual to execute somebody if they'd been on death row longer than 5 years. Well, that's good in itself, because it is appalling to keep people under fear of death for that long. But the problem with it is, if you rush to execution, you're going to execute people who later on it will turn out could have been exonerated. It was a capital case that was due for trial. So unlike a lot of the cases that amicus people deal with, which are post-conviction, in other words, they're in the appeals process, this was actually pre-trial. And as I had already quite a lot of legal experience in this country, which transferred fairly easily into the American setting, so that I could find my way around the law books fairly quickly, help to develop legal arguments. I was able to talk with the investigators and with the lawyers about tactics in the case. The principal evidence against our client was DNA, and I was talking with our expert in California about ways that we could challenge the DNA evidence and so on. And I also got, in particular, went to see a number of days of jury selection, which was probably the most extraordinary thing of all, because it was so different to anything you get in this country. And I haven't been able to go back out there largely because of, if you're not working here and you're going out there, if you've got to fund it yourself and all the rest of it. So the work that I do through Amicus now is largely to help to recruit people to go and do that work who are in a position where they can actually have the time and can go out and do things like an internship. You have to be over 21. You need to have a driving license because some of the offices are in relatively remote locations and you may need to be driving to various places. It's pretty well required for you to be a law graduate rather than a graduate of something like mechanical engineering, I'm afraid, for probably fairly obvious reasons, because the idea is that those who go and do internships should be able to assist the lawyers who are working on cases, and they really need to be able to hit the ground running, because the lawyers themselves are under a lot of pressure of time and don't have the time to spend a lot of time on showing people how to do things. It's a minimum of 3 months. Many people do between 3 and 6, some do longer than that if they can. The biggest drawback is it's self-financing. Amicus is too small a charity and doesn't have the funds to be able to assist people. And we generally say, in order to work out how much you're going to need, work out how many months you're going to go, and use, say, £1,000 for each month to cover airfares, accommodation, subsistence and so on. Which is really going to mean that people are going to have to think of it as like a gap year and get a job for 6 months, maybe 9 months, and then save up the money to go and do an internship. We have pupils at Garden Court North. As Queen's Counsel, I'm not allowed to have a pupil of my own. I think think it's regarded as being beneath the dignity of Queen's Counsel rather than for the benefit of the pupils. But I'm actually the chair of the pupillage committee at Garden Court North, and so I'm heavily involved in the recruitment process of pupils. The key thing we look for at Garden Court North is a commitment to the sort of work that we do. If somebody wants to be a commercial lawyer or to do tax law or something or other, I'm sure there are plenty of places where they'll get a terrific grounding in it, but there's no point coming to us. We want people who are dedicated to working on behalf of the underprivileged, people who've been discriminated against in the various areas of law that we work in. And we look for people who can show already their commitment to that by the things that they've already done. We get applications from people who have worked or are working in places like law centres, advice centres. They've done things like an internship, or they've spent years working maybe in a charity or something of that sort. They've shown already that they have a commitment. There's no use if somebody says, I'm very passionate about human rights and I did my dissertation in my second year on it, if they haven't done anything else. I mean, we understand, of course, these days that a lot of students have to supplement their themselves by getting jobs, and not everybody can work for a particularly worthy cause, and a lot of people will be doing just an ordinary shop job or something of that sort, and we understand people have to do that. But we look for people who can already show evidence of a commitment to the kind of work that our chambers does. We regard ourselves as being a bit different from just your mainstream barristers' chambers, where they will prosecute and defend and act for landlords and tenants and the state and the applicant and so on. We take a very clear stance in the type of work that we do and who we act for. And we're looking for people who are committed to working in those areas of law. If there ever was a time when people could just go to university, get a law degree, do the bar course and then get a pupillage, and away they go, if there ever was such a time, then I think it's long since passed. I think sometimes people need to think about taking a step sideways in order to move forward. And what I really mean by that is, if people are serious about becoming a barrister, then they have really decided they want to do advocacy. There are lots of opportunities to do advocacy, even if you're not able to call yourself a barrister, because you haven't actually, you may have been called, but you haven't done a pupillage. There are plenty of areas of law where solicitors' firms will employ someone who's done the BBC but hasn't yet done a pupillage, which will give them experience of advocacy, prison law, immigration law, various other types of fields of law. And if you get that sort of experience and then you apply to a barrister's chambers, you can immediately see why your CV is going to look much more promising, because you've actually been doing advocacy, and there's a clear commitment to what you want to do. So really, for people who are, if they're thinking of applying to us, then quite apart from the fact they should look at our website and see the kind of work that we're involved in and decide if that's the sort of work that they want to do. They really do need to think about ways of making their CV stand out. We offer either 1 or 2 pupillages a year, and we get in excess of 250 applications. So if you like, from the day the applications arrive, those people have got a less than 1% chance of getting a pupillage. Now, they've got to think about how do they make their application stand out so that they get to be one of the approximately 12 people that we will interview. And if somebody may come out of university with very good grades, but if they're 23 or 24 and really all they've done is a couple of mini pupillages, then they just aren't going to have the experience to make their application stand out as against other people who have been doing these sort of things sometimes for a number of years. Well, if I tell you that the principal areas of law that we do are prison law, so we're acting for prisoners. We don't act for the Treasury solicitors who act on behalf of the government, the Secretary of State for Justice or the Prison Service. We act for the prisoners. In inquests, we generally act for the families of those who've lost a relative in a death in custody, either at the police or in prison. In immigration cases, we act for asylum seekers and people who are desperate to establish the fact that they have a genuine fear of being returned to their home country and wish to make a new life for themselves here. We act for people accused of crime rather than on behalf of the state. We act for workers rather than employers. Now, some people, I guess, in my chambers will have a more political philosophy behind that than others. But the key thing is not so much the politics, it's the commitment to the underprivileged and people who've suffered discrimination. And the fact that we see ourselves as being in a position where we've been privileged by the educational and the opportunities we've had, and we want to use those skills that we've developed in order to assist people to basically allow them to achieve their own human rights and to establish their civil liberties. And that's really very much the ethos of Garden Court North. Well, there are probably two. One is funding. Almost the last act of the last government in relation to the lawyers at any event was to announce that our fees are being cut across the board by 13.5% over the next 3 years. But bearing in mind the new government and their spending plans, we may anticipate that will be cut even further. The other aspect that I think is very important for people to bear in mind is the possible reorganisation of the legal profession as a result of the Legal Services Act 2007, I think it was, which has introduced has the potential to change the distinction between solicitors and barristers so that it becomes almost a fused profession, which arguably could lead to the end of the independent bar and mean that lawyers gather together in larger groups, and some of them may be specialist advocates and some of them may be litigators and so on, but they're essentially, they have the same rank and there isn't the distinction that there is at the moment. There are opportunities or possible opportunities coming along for barristers to form partnerships and possibly companies which will allow them to make bids for tenders to do legal aid work and so on, which could change the legal landscape quite a lot. It's always, I think you have to be careful about being too scaremongery about this. I mean, I've been a lawyer for the last 35 years nearly now, and I can barely remember any time in that period when there didn't seem to be some possible threat to the future of the legal profession, and we're still pretty much the same 35 years later. What I think people can work on the assumption fairly safely is there will be a need for people doing law, either as litigators or as advocates, in the foreseeable future. I mean, whatever the government might like to do, they can't abolish criminal defence lawyers, for example, because they have obligations under the Human Rights Act and the European Convention to provide minimum standards and so on of representation. So there will, I think, always be a need for and opportunities for people to qualify as lawyers doing publicly funded work. It may be less well paid in the future than it has in the past, but you can still earn a living out of it. And so I think that people who are thinking about a law career and who are thinking about publicly funded work as opposed to commercial work and that sort of thing shouldn't feel put off. They may have to accept that they're never going to get rich doing it, but the reward that they get from the type of work that they do will more than compensate for the fact that they don't necessarily become materially rich people.